So as Laura said, my name is Dee. I'm from Disability Advocacy. And our organization is under Advocacy Law Alliance, so we're a sister organization for Mid-North Coast Community Legal Center. We've been working within the NDIS spectre, I guess, since the trial period in 2013. We've got offices in Newcastle as our head office. We've got an office that we recently opened in Parramatta to service the Nepean Blue Mountains. We've got an office in Tamworth, Armidale, Coffs Harbour, Port Macquarie, Intari, and Bathurst as well recently. So the NDIS has rolled out for the Hunter, the New England region, which includes Tari, and also the Nepean Hawkesbury region. So I'll be talking to you about the NDIS and more specifically the review process because I work there as an NDIS appeals officer. I'm also an advocate there. So the National Disability Insurance Scheme was introduced in 2013. It's administered by the National Disability Insurance Agency, and it operates as a system of supports to enable people living with disability to achieve their goals and their aspirations through choice and control. So what that effectively means is the scheme provides funding for people with disabilities to be able to receive support services to help them live regular lives. The NDIS shifts the way people with disability consider supports delivered to them. In the past disability sector system, funding was provided to disability services, and then people with disabilities would approach those services to obtain funds or supports that they had. It just meant that because their funding was with that service, if they weren't happy with it, it was a bit harder to move, I guess, to another service, if there were other services anyway. And now the way it works is the funding is directly given to the person with a disability or within their plan, and they get to choose what service provider offers them the supports that they need. Yep. So the NDIS Act is what sets out the rules and principles that guide decisions made by the National Disability Insurance Agency, including matters regarding the review of National Disability Insurance Agency decisions. Within the agency, decision makers are guided by the Act, the rules, and operational guidelines. Just some examples of supports that are provided under the scheme. People can obtain support workers. So for example, holidays aren't included, they're not paid for as part of a package, but someone, for example, if they've always wanted to go on a holiday somewhere, they can receive funding for a support worker to help them go on that holiday. However, they'll need to pay for their flights and everything, but they'll also need to pay for accommodation and stuff for the support worker. So the only thing that's included is the hours of that support person to help them through. Vehicle modifications are included, group-based therapies, support to maintain informal supports. So for parents who are carers of either children with disabilities or adults with disabilities, a person with a disability can receive funding within their plan for what used to be called respite, and that allows, I guess, for maintaining those informal supports because it gives the family a break and to recuperate, that sort of thing. Therapies as well, physiotherapy, occupational therapy, they're all included. Bills, groceries, rent, that wouldn't be included. Sometimes home modifications would be, it depends on the house, I guess, and the sorts of modifications that are required. Relevant legislation in terms of the review is obviously the NDIS Act, the National Disability Insurance Scheme rules, the Administrative Appeals Tribunal Act, and the Administrative Decisions Judicial Review Act. Key players within the NDIS review environment are the National Disability Insurance Agency, which includes the CEO, not directly, but delegates of the CEO through their staff. The decision makers, the reviewers, which are usually someone other than the original decision maker. Planners are the ones that mostly have direct contact with clients. Once it goes to the Administrative Appeals Tribunal, we have the members and registrars involved. We also have NDIS appeals officers, other people that work in my role. They've been funded by Department of Social Services to provide a free service to support people that are going through the appeal process. And as part of that, NDIS appeals officers can assist clients to submit applications to what's called the Central Assessment Provider officers. And all they do is they assess a case as to whether it's complex or novel. If it's deemed that it's either of those, they provide funding for that person to get legal support. And at this point in time, Legal Aid's providing that support across Australia. Onto the review rights. So once a decision is made, it's important to note who it affects. So anyone affected by a decision can request a review of it. Question as to whether it can be reviewed, and I'll go into what sort of decisions could be reviewed later. And if it can, if it meets both of those criteria, then a person could request an internal review directly from the National Disability Insurance Agency. If not satisfied with that decision, they can then request an external merits review through the Administrative Appeals Tribunal. So, Section 99, sorry, keep kicking that. Section 99 of the NDIS Act sets out reviewable decisions, and some examples include a decision to not grant access to the scheme, decisions relating to the supports within a participant's plan, and a refusal to review a participant's plan. So those are two different things. Initially, when you're approved into the scheme, you have a planning meeting, and during that planning meeting, you're funded for certain supports. So that's what's called your plan. If you're not satisfied with the supports that are included within that plan, you can request an internal review of that decision. A plan review is when you've had your plan for a period of time and you've encountered a change in circumstances and you wish to have it reviewed outside the 3 months of the internal review, they can conduct that, but the agency has a right to decide as to whether or not to conduct that plan review. And if they conduct the plan review and you're still not happy with the supports that are provided, you can request an internal review and then go to the external merits review process if you're not happy. But if the decision is upheld to not conduct that plan review, then at the external merits review stage, the decision you'll be appealing will be whether or not to conduct the plan review as opposed to the supports within the participant's plan. You can also review decisions relating to the appointment of a child's representative or a nominee of an adult, and decisions to revoke a person's status as a participant of the NDIS. So anyone who's unhappy with a decision that affects them, that's listed in Section 99, can request an internal review. An internal review must then first be conducted by the National Disability Insurance Agency before an external merits review could be lodged with the Administrative Appeals Tribunal. In making an internal review decision, the reviewer needs to consider a few things that are listed within the operational guidelines. Their decision needs to comply with the law. The NDIA delegate needs to consider the agency's policies that apply to that decision. The delegate needs to exercise judgment following careful consideration of all the important information. The decision needs to be properly recorded, documented, including important information and documents on file. And for reviewable decisions that affect a person, a statement of reasons needs to be provided to that person. Questions of fact and law are considered at this stage. There's a time limit of 3 months to request an internal review from the date of the initial decision, on the date that it was received. And to date, we've identified that there's not much flexibility around that. So if you're outside the 3-month time period, the agency isn't really flexible in adjusting that, or even in exceptional circumstances, not really. External merits review conducted by the Administrative Appeals Tribunal. It's independent, takes a fresh look at the decision, and by standing in the shoes of the decision maker, the AAT can either vary, set aside, or confirm the decision. The role of the AAT is to make a decision that's correct and preferable, and at this stage, questions of fact and law are both taken into account as well. While at the AAT, if the matter is approved for CAP funding, as I previously mentioned, then the Legal Aid Commission will provide that. In order to obtain this funding, participants can't self-refer for it. So NDIS appeals officers would be the ones that would need to submit that request on behalf of a participant, but their legal representative, their personal legal representative can also do that. And I would imagine then community legal centres as well as Legal Aid itself can submit a referral for this CAP. So it's just pretty much an argument of why that case is complex and novel. And there's some criteria around what qualifies as complex and novel. So once the legal funding's been approved and legal aid is providing the support, it's not means tested as general legal aid rules, and funding has been said to be limited. When the scheme was rolled out, they said the intention, I guess, and why they focused it on complex and novel issues was that they thought they'd have quite a large number of reviews going through in the first few years that would create some law around it, some precedents, and then there wouldn't really be a need for legal representation because there'd be some guidance around making those decisions, and then participants, the idea is to make it as informal as possible so that people with disability can put their own cases forward with the support of NDIS appeals officers as well. Despite that, the National Disability Insurance Agency will always have lawyers representing them within the tribunal. So that's not exactly same level. So 3 stages at the AAT. There's a case conference, which is usually conducted by a teleconference at this stage. And then there's a conciliation, which can be arranged. So the case conference is usually scheduled 2 to 4 weeks from the time the tribunal receives the T-docs from the National Disability Insurance Agency. And then another 2 to 4 weeks after that, a conciliation may be scheduled if at the case conference it was evident that the parties were willing to negotiate. And if a negotiated outcome cannot be achieved at either of those stages, it will be scheduled for a hearing in about 4 weeks from that period of time. There have been cases where there's been more than one case conference when extra information is needed. In some cases, the National Disability Insurance Agency has offered to pay for reports for additional information for them to reconsider. And also the CAP funding also comes with additional finances for reports and etc. If conciliation doesn't seem like an option for the parties, then hearings usually scheduled 6 weeks from the date of the case conference, just to speed it up. There's a 28-time limit to apply to the AAT from the date the decision was received, the internal review decision was received from the agency. They have exceptions, like in other jurisdictions that they cover, in terms of that 28-day period. And we've had a few clients that have had to go through that just because they were unaware of the review process that was available to them. So the relevant tests, in terms of eligibility, is set out in Section 21 of the NDIS Act, and that just covers mostly around the age, which is someone under the age of 65. Residency is also covered. As it was rolling out in the trial period, those specific areas were listed, but then it would be considered an Australian permanent resident. And Then there is the disability test, which is listed under section 24, and I'll go through that in a bit more detail later. And then there's also a 3-part test for early intervention qualifications, which is under section 25. I'll talk about that as well. Once a participant's been approved into the scheme, the participant supports need to meet the reasonable and necessary criteria, and that's set out in section 24. It's a 6-part test that I've got in there as well. So section 24 pretty much just states that to meet this criteria, which gets you into the scheme as a semi-permanent participant, it can always be reviewed and revoked, and your status could always be changed, but it's not like the early intervention one, which is limited to a 2-year period. So to meet this criteria, a person would need to have a disability that's attributable to either intellectual, cognitive, neurological, sensory, or physical impairments, or one or more impairments attributable to a psychiatric condition. The impairment needs to be permanent, and also it should result in a substantially reduced functional capacity. Sorry,
Dee, how have you found people applying for the NDIS with psychiatric condition that's determined to be permanent, like where the impairment is permanent? Is there case law around that? Is there much success around that sort of thing?
Yeah, so people with psychiatric conditions, there was a bit of a problem when it started out in the trial period initially, because of the permanency issue. That was the most difficult thing. But you note that subsection 2 actually states that the fluctuation of it doesn't mean that it's not permanent. It still means that it's there. But the decisions that were being made that we saw were that they were leaving out people with mental health issues pretty much because of their fluctuating states. They did a review of that and actually had to relook at all the applications that were made from 2013 for 2 years just to make sure that the right criteria was being assessed, and I think it was about 70 to 80% were deemed eligible after that review. Some of them under the early intervention criteria, but they were still able to access NDIS funds. And with the early intervention and mental health, I guess it's also a forum you could use to show the supports that you do need. So within those 2 years, if you show, well, I have good days and I have bad days, but when I have bad days, these are the supports I need and it's ongoing, that could potentially get you in through this as well. So, section 1, subsection C is pretty much the hardest one that we found. Most of the people that have been deemed ineligible have been because of that section, the substantially reduced functional capacity. It's quite a high test in terms of the substantially reduced capacity, and it needs to be in one of these criteria, so either through communication, social interaction, learning, mobility, self-care, and self-management. So yeah, as I mentioned, most of the people that have been deemed ineligible are usually around subsection C, and also the ones that have gone through the AAT and the cases upheld has been because they didn't meet that criteria, so it's quite hard to meet. And then part D is that the impairment or impairments affect the person's capacity for socio-economic participation. That one is not as hard, I guess, in terms of achieving. It's just that it affects them. It doesn't say that it needs to be substantially affected or anything like that. And also that the person's likely to require support under the scheme for the person's lifetime. That usually goes hand in hand with the permanency as well. Yes?
I was just wondering if you have an idea about how recent the evidence needs to be to establish these, so that people who have been on, for example, the disability support pension for a long time and were assessed 10 years ago, whether that evidence whether they require more recent evidence to establish eligibility.
It's beneficial to apply to the NDIS if they had like their old documents that they use for DSP and they're still on the DSP. that could be helpful, but it's more beneficial to have up-to-date records. There's also, within the access request form, there's actually a section which your treating doctor or even a social worker at a hospital could fill in. It's a functional assessment test, so it just pretty much lists about whether your capacity in these areas you need support, and it's mild, moderate, or intense support that you need. So if they don't have up-to-date medical reports, at the very least they'll need that completed. That's at least in line with those reports that they have to show that their condition hasn't actually changed. That would be the best way, I think.
Sorry, on that point, how big is that document that you're talking about? Like the doctors and medical practitioners charging for these reports to be done? Because like my concern is that usually medical reports are really quite expensive. Our clients can't afford them. We don't get legal aid funding to pay for medical reports. So, clients are in a situation like a doctor's going to charge that, or is it like a one-page thing I can print off and give to my client to take into the doctor with a short cover letter? Like,
it's a 3-page thing. Most of them are like multiple choice things, but like it requests for more information, and the more information you give, the better. Some clients have good relationships with their doctors and they're happy to do that during one of their sessions with them, but others are being charged for it, and it is becoming a business. And that's why I mentioned that social workers could also fill it in, but it's not as, the weighting might be a bit different if it comes from their treating doctor as opposed to a general social worker at a hospital. So it would still definitely be the cheaper option than getting the medical reports though. In regards to the early intervention requirements, so a person meets this criteria if they've been identified to have an intellectual, cognitive, neurological, sensory, or physical impairment that's likely to be permanent, so that's similar to Section 24. And that one or more of these impairments are attributable to psychiatric condition or are likely to be permanent. So that's the same as Section 24(1)(a). Or it also applies to children with developmental delay can get in through the early intervention criteria. So the CEO needs to be satisfied that provision of early intervention supports is likely to benefit the person by reducing a person's future needs or supports in relation to disability. So that's the main criteria there is if someone has come in with a disability, that if we put in intense supports in the beginning, could this reduce the need for supports on an ongoing basis? So if they can meet that criteria, then they're usually in. I will say it's much easier for children to get into this if they have developmental delay than it is for adults to meet the criteria. And as I mentioned, most of the adults that are meeting this criteria have psychiatric and other mental health disabilities. So the CEO also needs to consider that the provision of early intervention supports for the persons likely to benefit them by mitigating or alleviating the impact of the person's impairment upon functional capacity. It's not as big as Section 21(1)(c) because it's not about substantial functional capacity. And also about same issues: communication, social interaction, learning, mobility, self-care, and self-management. And it needs to prevent the deterioration of such functional capacity or improve functional capacity or strengthening the sustainability of informal supports available to that person. Once a participant's been approved into the scheme, Section 34 is then considered. In the beginning as well, what we found was that during the access criteria or the assessment at that stage, the National Disability Insurance staff were actually taking into consideration Section 34 in making their decision as to whether someone would need the NDI supports for their lifetime. That was raised in one of the cases that we had, and the tribunal members clarified that it was multi-stage process, and this shouldn't come into whether or not a decision is being made about whether someone will need supports for the rest of their lifetime. This just needs to be done later. So specifically the case that we had, the individual required some support to mow their lawn, and the NDIA's argument was that they wouldn't fund that, and they have in other cases, but in this case they said they wouldn't fund it. And that was the basis of their argument, but during the tribunal it was mentioned that the support that was being requested shouldn't even be considered at the time of assessing a person's eligibility. The only things that should be considered should be Section 24, really very broad, nothing specific about what that person wants once they're inside the scheme. And as a result of that, it also brought up that there's potentially a situation where someone could be a participant of a scheme and not have funded supports at a particular point in time. So they could still have a plan which would have supports coming from everywhere else, whether it's informal supports, for example, or supports through the health system, but they qualify, and just at that point in time in their lives, they don't need any NDIS specific funded supports. That shouldn't exclude them from accessing the scheme. So some things to consider is that the support will assist the person to pursue their goals, objectives, and aspirations. The NDIS is very centered around individualized support and for people to achieve their individual goals and aspirations. So also during the planning meetings, if a person connects, I guess, the supports they're asking for to their goals, they're more likely to get that funded than if they go in, for example, with just a shopping list, I need all these supports, but none of those are actually attached to the goals that they want to achieve within that year. The support would assist the participant to undertake activities and to facilitate the participant's social and economic participation. The supports represent a value for money. That's also a very big argument that the NDIA has been using within the tribunal. And it's usually a fallback argument if all other cases are raised, and in newer supports especially, the tribunal has been asked to consider whether or not offering that support to someone would affect the sustainability of the scheme, because if it opens up the gates and everyone starts to request certain support. In one specific case, it was massage therapy, which really worked for this particular woman's condition, and the argument was if all the participants then requested massage therapies, would the scheme be sustainable? So that's a big one that they use a lot of the time, and it's always one of the arguments within the review process. The support also needs to be likely to be effective, beneficial, and having regard to good practice. So again, newer therapies are a bit harder to prove within the AAT. They usually want to go with evidence-based therapies that have worked for people. In one specific case as well, I think it was McCrudden, they relied heavily on a participant's lived experience. So even though the therapy she used for her condition wasn't one that was commonly used for people with that sort of disability, she had evidence that it worked for her, because the period that she stopped using it, she deteriorated and needed the use of a wheelchair. But as soon as she started to regain her mobility back. So the tribunal took that into consideration and actually approved that funding based on the fact that for her specifically, there was evidence to show that it was beneficial, even though it wasn't common practice for people with that disability. And then the funding of that support needs to take into account what's reasonable to expect families, carers, and informal networks to do. So anything that parents would need to do regardless of whether their child has a disability wouldn't be funded under the NDIS, for example. And also, another big one is that the support needs to be most appropriately funded through the NDIS and not funded through other general systems of service delivery. A big one they refer to is the health department. So if a support, for example, can be funded through the health department. The fact that the health department doesn't fund it would not guarantee that the NDIS will fund it. Yep.
Would you like a glass of water? You got some? Okay.
There's further appeal rights. If someone would like to challenge an administrative appeals tribunal decision, they can appeal that to the federal court, but this can only be done on points of law. If there's any other issues, we've had one that has gone to the federal court that was successful and then remitted back to the AAT to be re-looked at. It wasn't successful when it went back to the AAT. So I mentioned before a brief difference about a plan review and a review based on a participant's supports. So a participant can request a plan review at any point in time. It doesn't have to be within the 3-month period, and it needs to be based on a change in circumstances. The CEO has 14 days to make a decision. If a decision isn't made within those 14 days, the CEO is deemed to have made a decision to not conduct the plan review. So at that point in time, if a person doesn't hear back within 14 days, they can actually request an internal review of that decision. Yes?
Are they notified of that 14-day period?
No.
So it's okay.
So there's not, the information isn't being sent out very well, and most people don't actually know that you can do that.
Yeah.
So we've had some clients that have been waiting 3-4 months for a decision under this, whereas if they didn't know, then they could request an internal review. So it's more about information, I think, and I think the older the scheme gets and people are a bit more aware, hopefully that will get triggered. We're looking for a test case at the moment, and we're hoping one of the clients we have who requests that would be on board so that we could do something about it then, so we'll see. Yeah, so also when you request a plan review, the difference to an internal review about planning supports is that the whole plan is under review for a plan review. So potentially supports could be added or subtracted. It depends. They review the whole plan. Whereas if you request a review based on the supports that were in there and you do an internal review within the 3 months, it's about that specific support that you're asking as to whether or not they'll grant it to you. Other avenue within the, that we assist clients with is complaints. Since the NDIS rolled out, there's been some confusion around complaints and reviews with both clients and also NDIA staff. And I think in the last quarterly report, not the newer one, I've got some stats later for that, but the one in 2015, I think, showed that there were about 628 complaints versus 248 reviews. I don't know specifically why, but we, would come across clients who would be, I was unhappy with a certain decision, this is what I did, but it was being channeled through the complaints avenue as opposed to the review. And of course, as you know, you get different outcomes with a complaint and a review. With a complaint, you can get a sorry, but nothing changes. And with a review, someone has to actually look at it and remake a decision around that. And you can then go to the AAT as well to get an independent view.
Quick question.
Yes.
When somebody lodges a complaint, do they actually have somebody to help them as far as going through forms? Because that can be rather daunting.
It can be. We're available as an advocacy service to help with those sorts of things, but when they go to the National Disability Insurance Agency, the staff at the front is supposed to help. They don't always.
Because the reason I'm asking the question is triggered by the statistics that you just gave as far as 600 odd versus 200 being approved. That's a huge difference. So
Yeah.
I'm just wondering, with that 400 odd, would that be because maybe when the application was done, they didn't really sort of address their complaints in such a manner that they could really show what their grievances are?
Well, those figures were a comparison between what was looked at as a complaint and what was looked at as a review or an appeal. Yeah, so it was still clients, like out of those 800, all of them were clients that spoke out, except that a lot of them were being treated as complaints as opposed to the reviews and appeals, yeah.
But the ones that were complaints, were the outcomes for those?
Not sure, because those figures were from the quarterly report, and they just wrote the figures of what were complaints and what were reviews. So I'm not sure what outcomes would have come out, but they wouldn't have gone to the AAT, so they wouldn't have been recorded as an appeal. So I'm not sure.
Sorry.
Yeah, sorry.
If someone calls or contacts and they say that they want to make a complaint, and it's clear that what they really want is a review of the decision, is that then funneled across and it's dealt with as a review, or is there a specific form of words or written application that needs to be lodged for a review?
That was the idea. So we've met with the National Disability Insurance Agency, and their plan is when a person calls to decipher pretty much what they're asking. So for example, if they're complaining about treatment from their planner, it's most likely a complaint, but if they're complaining about not receiving a support in their plan, it should be understood that that's probably a review. They want something done about that, not an apology. But that wasn't always happening before. The National Disability Insurance Agency has now created a specific department, I guess, within the agency which deals with reviews now. It might change, I'm not sure. We're still kind of watching. Yeah, so some examples, there's treatment by a planner and also delays in processing, finalising internal reviews. One example of a complaint that we had is a participant of the NDIS requested a plan review in April last year in accordance with Section 48, which is the one about the plan reviews. The participant felt that their plan didn't meet their goals or their needs. The plan review was actually approved, so it was granted, and there was a planning meeting in May. 3 months later, however, the participant didn't receive their new plan. And under Section 49 of the Act, it states that if the CEO or their delegate conducts a plan review, then they must facilitate the preparation of a new plan. So within that period, the person effectively didn't really have a plan because they had their plan review and then they didn't have a plan created. And as a result of that, that was treated as a complaint because the review had gone through. So we requested the internal review that had the planning meeting, and without the plan as well, it was almost like a decision wasn't made, so that couldn't be taken further to the AAT, so the 28 days hadn't yet started clicking, so the only option we had was to lodge a complaint alongside that. That sped it up, we got a decision, and they got most of what they had asked for except for about 2 things, which they then chose to appeal further within the AAT. Just some stats for you. This is the most recent report that I found. I don't think they've released the last quarter yet. So from 1st of July 2016 to 30th September, there were 35,570 access requests made to the NDIA. Out of those, 28,600 were found eligible, about 2,600 ineligible, and there were still 3,500 being processed at the time the report was made.
If I may, sorry.
Yes.
A quick question. The one you had the statistics for those that were not eligible. Again, I asked the same question. The ones in those instances, when they actually do the application, you actually ran through all the different clauses that they need to meet as far as the criteria is. The criteria that they need to meet. When they're lodging their applications, wouldn't they know at that point in time whether they would meet the criteria?
Not necessarily, because like you'd know that you have a disability. Yes, that's pretty easy. You'd know that it's permanent because
there,
you need.
there was a lot of aims for A,
Yeah,
N,
so it
B,
was,
C.
you had to meet all of them. So
Yeah.
under that section 24.1, you had to meet all 5 of those
Yeah.
criteria. And the hardest one, as I mentioned, was the C, which says the substantially reduced functional capacity. That's, it's not as obvious in terms of assessing it. Like you might go and see someone and for you, you might feel really limited, so you feel that you have a substantially reduced functional capacity, but then you go to, if they read the assessments and it's not meeting that criteria, then you can potentially not qualify. So it's not always guaranteed that when you're submitting your application, you know you meet the requirements. There's a few disabilities that have been listed as deemed to be eligible, and also people with disabilities who receive adequate funding and are in supported accommodation, they're also deemed to be eligible within the NDIS. So it's mostly for new participants, and also in the newer system it's a bit broader, so people that potentially weren't qualified to receive disability supports in the old system can now, because it's for more disabilities and it's just a bit broader.
Do they need some sort of doctor certificate that shows what level of disability they've got, like what percentage? Like for example, that they would need to be at 21% disability to meet the criteria,
Yeah.
for example.
That'll be hard to prove, and I think that's why the agency focused their substantial reduction, because how do you put a percentage on someone's incapacity? It's more about, and I think they were moving away from labeling disabilities as well. So for example, rather than saying if you have autism, then you qualify, it's more of how does that affect you in your daily living. And so sometimes, you might have a different condition that really affects a particular person in their daily living because of other circumstances that are surrounding them, but it's partly because of that disability that they're so reduced in their functional capacity. So that's where that comes from. It's supposed to be an individual assessment of, well, okay, so you've said you have these conditions, but how does it affect you? So it's not enough to say, I've got a broken leg, or, you kind of also need to say, so therefore I need to use a wheelchair, so my mobility is limited, I can't easily access wherever, like everyone else. You have to connect that to the reduction in your capacity and how it affects you. Sure. And just to break down the stats before, so there were 35,500 access requests, and within New South Wales alone, there were 22,754. Clearly the highest.
Files have got lost.
Yeah. And out of those 22, 19,000 were deemed eligible. So almost 3,000 that weren't, and I'll move on to the appeal stats soon. As a result of that, New South Wales had a total of 24 appeals that went to the AAT. So these are decided decisions, I guess, and in total there were 94, but it's just a big gap still. Like you're speaking about under 100, and yet there's a large group of people, and that's just access, so that's not even talking about people that are not happy with the supports that they've got that also request reviews. That's just in general trying to access this scheme. You'd think that there could be a bit more reviews, I guess, or appeals, but yeah. I have a list of some case law ever since the NDIS rolled out. There's been 16 cases that have been decided within the AAT, so these are actually published decisions. A number of those cases, of the cases that go to the NDIA, get resolved via negotiated agreement, so you wouldn't get the decisions published or anything like that. And as I said, so there was one that went to the federal court, and one, I believe, that's going through federal court at the moment. Yes.
So DA is not running, they're not providing legal advice, they're not running the cases, but you're facilitating the referrals to legal aid?
Yes, we're facilitating referrals to legal aid, but we're also, whether or not the cap's provided, we're supporting people throughout the process, because you don't need to be legally qualified within the tribunal. So we're just there supporting them, pretty much explaining what the stages are, what's happening, what to expect, I guess. And it's more of a support while the person puts their case forward. That's if they don't have legal support. In most cases, we have received legal funding since it rolled out, except for one. We have one case at the moment that doesn't have legal representation. It wasn't deemed complex or novel.
And your catchment at the moment, sorry.
Yeah.
Your catchment at the moment is all of Sydney, is that right?
No. So within Sydney, we only have funding for the Nepean, Hawkesbury, Lithgow, and Blue Mountains region. Is what we cover within Sydney. And then we do the whole of the Hunter and the whole of New England and Central Coast as well. Yeah. So,
are there other services?
Yes, there are other National Disability Advocacy Services that have been offered this funding. Again, is to ensure the choice and control. Not all of them have decided to take it on. Some are still deciding. So there have been, I believe PWD may have been offered contracts for it. I'm not sure if they've started. And I also believe side-by-side advocacy might have the whole of Sydney. They were still deciding, that much I know. So there's a few other services, I guess, that have been funded. But while it was during the trial phase, DA was pretty much doing the trial areas. That's what
I know
indicated.
DA very well, obviously.
Yeah, I know.
And yeah, so DA's got a really high level of service, but I just don't know how much. Everybody in the room is from all over New South Wales. And I'm not sure how many people are going to be covered by a disability advocacy service, you call it?
Yeah. Well, right now, because it's only rolled out in various areas, it's rolling out slowly, as you know. So as they're going into other catchment areas is when they're getting new services, I guess, on board in those areas. So within the Hunter, we were the only advocacy service that was there, put our hand up when we got it. So it was just the Hunter for New South Wales for 2 years, pretty much. And then Nepean, Blue Mountains, those 4 regions that I mentioned also rolled out. So New England and Central Coast just recently started, if I'm not mistaken. So they're kind of, DSS is kind of growing the funding as the scheme rolls out as well, and targeting other services. In terms of the legal aid funding and the support, they're considering how that's going to continue and who will be providing those services. It hasn't yet been decided. But obviously we've given feedback that if the agency will always have their lawyers there, it's only fair that the clients also have access to ongoing legal representation somehow. They can put whatever criteria they want, but it can't just shut down. And they've taken that on board, but they're still deciding how it's going to look.
In terms of referring clients to you, you just refer to your main contact number for Disability Advocacy New South Wales, and that gets moved on to...
Yeah. So, we've got a referral form on our website, and it's the same process, so clients can directly contact us.
Just wondering if you have a sense of how good the internal review system is, like how often it's referring the decision or not?
In terms of outcomes, I'm not sure, but I will say that because we work on internal reviews as well, and a majority of the ones that we do support clients with move on to the AAT, and then they're mostly resolved via conciliation, but they do. And partly what we found is that frontline staff aren't really considering the act as much, so it's more so, because when you go to the AAT and you're dealing with the lawyers, a lot of the times there's clarification around certain things, and they kind of mention sections in the act and sometimes wonder why it got that far in the first place. So it's a training thing. They've identified that it's also a training thing, because they mostly train their staff around the operational guidelines, which were created based on the rules and the laws, but a few things are still kind of missing, I think. So with the developed department, I guess, within the agency, we're hoping it will improve, because then that will be specialized staff only doing reviews. But to start with, it wasn't that good. Yeah. Anyone else have any other questions?
Yes. What was the time limit to go to the federal court from the AAC?
I believe it's 28 days, but I might need to check that because I didn't put it in. So
It
I
should be
can.
28 days, because I think it's.
Yeah, that's what I thought as well.
Yeah.
Yeah. Anyone else? Oh yes.
So, what is the time frame from being approved to be eligible to when the CEO needs to facilitate the plan, start facilitating the plan?
They don't have a time frame for that.
Right. In the Act, it talks about reasonable period of time. It's not prescribed by the rules.
Yeah.
Is there any discussion or guidance about what is a reasonable period of time?
Not yet, and at the moment we've been raising that a lot in our complaints because some internal reviews are taking 6 to 8 months. So not reasonable, I don't think. But the agency has mentioned that it's because they're transitioning such a large group of people into the scheme. They're facing some delays, but then it's a bit ironic that they're not flexible around the 3-month internal review submission thing. But so it's a developing scheme, I think, and I think with time it'll. It's teething problems, a lot of it, but at the same time you get a lot of people that are disadvantaged when they're waiting 8 months to get an internal
that means
review.
a person could be approved or could be eligible for the participation, but just sit waiting for an undisclosed period of time.
Yeah, and it has
before they have
happened.
assistance.
And then, so in a case like that, when the delay is so long, obviously most of those supports were totally inaccessible to that person. But if they've spent their own money or something and they've outlaid costs for a period in which they were eligible, is there any retrospective reimbursement?
So what's happening is people with disabilities who were under the ADIC system, the old funding system, their plans are usually carrying through. So there's continuation of supports that was considered at that stage. This usually affects new participants, so ones that have never received services at all and then apply, that just wait with nothing.
Added clients transfer costs, do they?
Yeah.
Automatically?
Not automatically, but they move depending on the service provider they were with. They've been transitioning them in slowly, but the plan that they had while they were with ADIC continues until they do their plan with the NDIA. Yes?
How do you have a hearing, say for example, in a rural or regional town? Like what makes a client eligible, like if they go to the AAT, the AAT to hold that hearing, say in Ndinawe where we're from, rather than the client having to go and travel to Sydney for the hearing? Like I saw in your slideshow, you have like a little bracket that said.
Sometimes they come.
Yeah.
Yeah.
What would be, like how would I get that to happening?
If you put a request in, the way we got the ones to come for us was the person, we don't, obviously, our Newcastle clients would need to come to Sydney, but the people that we had mobility impairments, and so it was difficult for them to travel. And it was initially suggested to try and do a teleconference hearing, but they also had some difficulty with